Welcome to the Open Talent Report, the award-winning podcast where we dive deep into the emerging trends in global employment, the future of work, the talent crisis, the demographic deficit, and the new world of work with our expert host, Conor Heaney. Conor is the managing director at CXE EMEA, a company that takes the hassle out of finding, compliantly engaging and paying contractors anywhere in the world. In this podcast, Conor brings you captivating conversations with top CEOs, visionary founders, and industry experts. Together, they shed light on all things open talent and the evolving nature of work itself. So grab your headphones and join us on this exhilarating journey.
Hello and welcome to this week's show where I'm delighted to be joined by Gareth Walls, partner at A&L Goodbody. For those of our audience who don't know, A&L Goodbody, according to Chambers, are ranked as a leading firm across Europe, and they are the tier 1 legal firm in Ireland across 24 categories, which is some going. I've had the pleasure of working with Gareth. Gareth has been our external legal counsel in A&L Goodbody in my day job for coming up to about 10 years. And I think it's fair to say that Gareth and his team are some of the leading employment and labour lawyers in the UK and Northern Ireland. So Gareth, it's great to have you back on the show. I think from memory, Gareth, you were our first ever guest back 4 years ago. So it's great to have you back on.
And yet you had me back, Conor. I am lovely touched. No, I really appreciate it. Actually, it's funny just hearing that intro and not the history necessarily of ALG, but how we have worked together for such a long time, because it has seemed like a flash. And I think when we get into some of the things we're going to talk about today, that is going to be apparent, because the pace of change in our world, I think, is easily the most dynamic within corporate law and employment law. The pace and the scope of change is only accelerating, and it's fascinating to think we've been at this for so long. Although it does make me feel old when you feel like that.
Well, I'm going to say we're still looking young, Gareth, but it's great to have you on. And Gareth, I really wanted to have you on because it has been a reasonably long time since we first had you on, but particularly for our UK audience and members that have business interests and employees in the UK, I think it's even more important to have you on, principally because of what's been described as the Employment Rights Bill in the UK. And I think this Employment Rights Bill, according to some commentators, has been one of the most controversial pieces of legislation in this space for some time. There's been a lot of organizations such as the CIPD welcoming it, of course. But Gareth, like all legislation, it's always great to get your take on it. And I must say, just for the benefit of our audience as well, Gareth is here. Obviously, he's representing A&L Goodbody as a partner, but please do not take what he has to say as legal advice, nor should it be construed as. So, Gareth, now we've got the disclaimer out of the way. How the hell are you doing?
Yeah. I'm great, Conor. Thank you so much. Absolutely. And I think the Employment Rights Bill is a fascinating place to start. It has already drawn an awful lot of commentary, and as it continues to pass through the Commons, it's only going to attract more and more commentary. So anything that we say now will be a snapshot based on what is the application now. But as a piece of legislation, I think it is deeply flawed. And it's deeply flawed not just because of pure drafting, but also because I think it's allowed itself to become increasingly politicized. And I think that's a major problem for any primary piece of legislation, especially one which is so significant in that it's to deal with employment, which impacts every sector, public, private, charity, everything else throughout the United Kingdom, either directly or indirectly. And which then has a secondary and tertiary impact through case law, etc. And what this bill has done, to my mind, has replicated some of the electoral pledges which the Labour government placed in its manifesto pre-election, but in its first 100 days, which everybody indicated they would try and put out a bill. They have put out a bill which has only faced criticism, not just from the ineffective opposition because the Tory opposition is too small to keep this anything other than being a politicised piece of legislation. But the RPC, the Regulatory Policy Committee, has challenged it. The Labour government brought out an amendment to its own policy within a week of it, or within a week of the bill being issued, and that was a 58-page document rectifying and clarifying elements of what it had produced. So we have, as we speak today, Conor, we have a need for a reform of employment legislation, but we have a deeply unhappy vehicle which is seeking to do that. And I think the really frustrating thing about it is that there's an awful lot within the bill which is really positive, really necessary, and really good for business, and more importantly, really good for the individual, like pregnant workers, etc. The returning mother, there are additional rights in there which are absolutely right and good. But those are somewhat lost in some of the more headline-grabbing elements, which are also those which haven't had a proper impact assessment conducted on it. And those are the issues which are going to take up more and more airtime as it passes through the Commons, and ultimately, potentially, make for bad law. And that's a real worry with the Employment Rights Bill. And here's a great example. It was initially indicated that there were going to be day one unfair dismissal rights. Now, just to put that in context, at the moment, unfair dismissal rights in the UK are after 2 years service. In Northern Ireland, it's after 12 months service. So there was already a disparity which had landed between the two principal jurisdictions as a consequence of the previous piece of legislation, which is the Employment Rights Act 1996, which has served us really well for 30 years. But with these day one rights, the unfair dismissal rights, both those thresholds were being reduced from 24 months to 12 months, which created massive issues for business and industry. And a week later, the government said, well, we didn't really mean day one rights. What we meant was day one rights once you satisfactorily complete a probationary period. And then they said, in the probationary period can be as much as 9 months long. So we don't actually have day one rights. We have 9 months plus 1 day rights, potentially, for unfair dismissal, unless and until they clarify this as it works through the Commons. So issues.
So, Gareth, I want to come back to this in a few minutes if we can. I want to really look at what your opinion is on its impact on the labour market flexibility, because the UK always strikes me as a flexible labour market, along with Netherlands, Ireland, Southern Ireland, or Republic of Ireland, and the USA to an extent. Out of the Western labour markets, it's probably in that Goldilocks zone where it's really good for employers to engage workers or disengage workers within certain parameters. But let's come back to that, Gareth, because I just want to come on to your origin story, and I just want to focus briefly, if we may, on the problems and challenges that your firm solves for. So, like you, Gareth, I grew up in Northern Ireland. For our US audience, Northern Ireland is part of the UK on the western fringes of mainland UK. It's known for its really good schooling system. It's quite a stratified society whereby if you become a lawyer, a dentist, a doctor, a teacher, an accountant, you're sort of set, right? And we'll come on to maybe why you might not be set in the future in those professions. But Gareth, it's a difficult journey in Northern Ireland to sometimes get into those professions, right? Particularly if you didn't go to the right school, even if they're what's known as a public school or government funded school. But just for the benefit of our audience, would you mind just telling our audience your origin story and how you became a partner at A&L Goodbody?
Yeah. So even within Northern Ireland, I'm from the west of Northern Ireland, so pretty much a rural upbringing. School was a bus ride twice a day. Basically 40 minutes to get to a school of any scale. I went to England, we'll call mainland Great Britain, for undergrad, university. And then I stayed and worked in England for 9 years, which is why I have a good understanding of the English network system, legislative framework, etc. And then I moved back to Northern Ireland in 2002 and worked for what was an Indigenous commercial practice in Northern Ireland. That was subsumed by an English firm which had acquired it. I had moved on to A&L Goodbody. A&L Goodbody is a Dublin-based firm, and it was dipping its toe in the northern market. I could sort of see that the peace dividend in Northern Ireland at the end of the Troubles was changing the future of business and free movement of workers and opportunity in Northern Ireland. And to their credit, they assembled a small team of trusted lawyers they'd worked with. I was fortunate to be one of those. And when we opened the office in Belfast, there were 11 of us. And that was, I think, 18 years ago. And now there are 150 of us in Belfast alone. Now, that is not major on a global scale, but it is very significant for Northern Ireland. So a full service corporate law firm with 150 plus employees is quite significant. And the thing I found in my career to date is that unless I was particularly interested by a vehicle or a group of people, unless I shared their cultural expectations, integrity, ethos, etc., I just wouldn't have stayed. But I've stayed with this business and I've watched it grow and played a really, I suppose, played a part in watching it grow and develop. And it was never a bums on seats piece. It was always intentional growth, get the right people in, get the right cultural fit, and let's see what that might bring. But it's always with a view to serving the local community, the business community, and individuals, and trying to do law right, law and business blended the right way. And that's why I found it so interesting, Conor. And that's why I've stayed, frankly, for such a long time. But it has been really interesting watch the dynamic of law and practice and business in Northern Ireland begin to diverge away from traditionally its GB roots and the UK roots.
Yes.
So Northern Ireland is now in a really unique position. We are the only part of the United Kingdom which shares a land border with the EU. So we have this opportunity, I think, to really kick on again and work in Northern Ireland, watching business and people move between getting all the benefits of the EU and all the benefits of the UK. And we are a little bit of a melting pot. I think we are a little bit of a head scratcher, both for the UK government and for EU and Brussels. But nevertheless, real scope, real potential, and great place to live and work. And all good.
Yeah, I agree, Gareth. And it's interesting, Gareth, when you move away from Northern Ireland to the England or mainland UK or mainland GB or further afield, and then when you come back. But I think if I could give if my kids are lucky enough to experience that, Gareth, when they're older, it's something I would recommend, is maybe getting away and either to study or work, and then of course coming back if they so wish. Would that be something you'd share, Gareth, with your kids, to maybe just get out and see a bit of the world before coming back to Northern Ireland?
Oh, absolutely. I'm a strong believer in that. On two levels I impact in that, Conor. One, as a father, I would strongly encourage my own kids to leave Northern Ireland and to broaden their perspectives and to see something of the world, and just broaden their horizons. There's so much positivity out there. Sometimes Northern Ireland is still a bit negative. We still have quite a conservative society, and sometimes that is too easily brought back into the religious perspectives, which are divisive. So I would, as I said, strongly encourage my girls to leave Northern Ireland for a period of time. And here's the important bit: but I would want them to come back. I think that they will bring back. It'd be good for me personally, being fairly selfish, but they need to come back with those broader perspectives and contribute back into the society and bring a different perspective to it. I think it was really important for me. Both my brothers did exactly the same. We're all back now, and I think it's just really, really helpful. So that's one element where I would really be a big advocate of broadening your horizons. The second way I impact in that, I do an awful lot of the recruitment and the assessment of potential applicants into A&L Goodbody, which is a large corporate law firm and a really attractive employer in this jurisdiction. And a lot of potential candidates are classic grammar school, undergrad in law, want to start work. And they think that that must be the appropriate model. And I would encourage them to say, well, actually, no, I like to see candidates that have gone away and done something completely different and have traveled or have lived abroad or have been an engineer for 5 years or have done something and then have decided that they want to come in because they have a real passion for the law. And I think those candidates, whether they're considered mature students or an indirect career path, they are so much, they have so much capacity to really positively impact the workplace as well. So in both those perspectives, I think be assured that you do not have to go through the traditional career path to secure a job, and B, get out, bring something to any employer which illustrates something of your personality, which is broader minded than perhaps it can be if it's just straight through academia and then into your first job. And there's so much more scope to develop a career in that. And even if you consider the particular industry which I'm in, which is the legal industry, and we know the legal industry is sort of under attack from new developments in tech and new developments in way of doing basic legal work. Whenever someone has gone away and done other things and they come into that industry with different skill sets, mindsets, approaches, problem solving solutions, analytical skills, it's incredibly exciting, because even the kinds of law we do didn't really exist 5, 10, 15 years ago. And the kinds of law we'll be doing 2, 3, 4 years from now again will be different. Energy law, tech, comtech, AI, all of those are huge and burgeoning areas of the law, which leave traditional areas of the law like criminal work or residential conveyancing or property so far on the back burner that those are just not exciting. A to me, B to new candidates, new job applicants coming in. Whereas the future of law, if you're prepared to harness the changes and accept them, is really quite exciting still.
Yeah, I agree with you, Gareth, and I think it's great to hear how the profession of law is becoming perhaps more inclusive, if that's the right phrase, from different parts of the education sector or different parts of the world. So, Gareth, just if we may come back to the Employment Rights Bill, are you concerned about its potential impact on labour market flexibility in the United Kingdom and Northern Ireland?
So I think the Employment Rights Bill is a bit of a disappointment when it comes to flexible working, 0-hour contract working, and the ability of the employer to adapt and change to meet the changing business needs, which the world forces upon us. As I said at outset, Conor, it's a kind of bill that has an awful lot of good stuff in it, but there's an awful lot of nice words and phrases that don't have a whole lot of substance and need to be tracked through. One of the things that was a big driver for the Employment Rights Bill was the P&O case of a couple of years ago, whenever there was a capacity under the GB English legal system to hire and fire, which was, or rather to fire and rehire, where an entity needed to make significant change to the contractual arrangement to maintain the business as a going concern because of financial necessity. P&O Ferries did that and overnight fundamentally changed the nature of a number of workers' contracts for employment. They realised they couldn't do it through consultation. They didn't have time or capacity. So what they did was they unlocked this relatively unknown area of GB law, which was to fire and immediately rehire on what they would have considered were still positive terms, and therefore would have mitigated the risk of the individuals claiming for unfair dismissal or fundamental breach of contract, etc. No, it didn't work. It didn't work. It was immediately in the public eye. It created a huge amount of debate at parliamentary level, and it is one of the elements that has now tracked through into Employment Rights Bill in relation to making the ability to fire and rehire almost certainly unlawful. Now, I'm caveating that because there's still an ability to do a fire and rehire, because as a concept, it was bound up in traditional GB redundancy legislation and how to do large scale restructuring and reorganization. So in and of itself, it is not unfair, but
Yes.
it was a concept that required a lot of consultation, and it needed to be done bound up with a proper redundancy piece. It wasn't. So instead, we have a large amount of noise made about that in the Employment Rights Bill, and yet that came out of one bad case and one inappropriate set of circumstances which social media projected to the forefront of everybody's perspective. And so you have another case or an example of a terrible situation with one employer making the press,
Yes.
getting it into Westminster into public debate, and now we have it enshrined in new law. But it's not going to change or impact a significant number of employees, nor will it change or impact a significant number of employers, because in 25 years of doing this, the time whenever firing and rehiring has come up is probably, you could count the fingers of one hand, and even then it's an option which is considered unpalatable. And yet we've got it in this legislation. So that whole piece, too much noise has been put onto an area which really doesn't help business, and it really doesn't help employees. Then we have the flexible working changes. And we have the impact to try and dampen down 0-hour contract working. And 0-hour contract working, the solution to that within the Employment Rights Bill is to try and create employment rights for those individuals enshrined around guaranteed hours for the hours those individuals would normally work. But the whole point of a 0 hours contract, whenever it works for employer and employee, is that it creates fluidity and flexibility for both. So a nice soundbite, which is to give 0-hour contract hours working tick based around the hours they would normally work, immediately takes the benefit away and changes the construct of what a 0-hour contract worker actually is. So again, I don't think the bill actually achieves what it sets out to do there, whenever what it should be doing, and doesn't do enough of in this bill, is looking at the really vulnerable categories of worker stroke employee and enshrining their basic rights. The changes they're making to flexible working don't do that,
I see.
even if classically for the flexible working statutory scheme, you're allowed to apply twice in a calendar year, and it's a day one right as opposed to a 26-week qualifying period for that. Well, that really doesn't make much difference, really, because a good employer will ignore the timetable thresholds anyway. If they have a good employee that comes to them and says, because of the needs of my lifestyle, whether they were perceived or they landed on me out of the blue, I need to fundamentally change the way I work. The good employer will work with the good employee, and they will create something, and they will facilitate that. And that happens day and daily in scale. So taking a soundbite and saying your flexible working application rights, you don't have to wait 26 weeks. You can do it in day one, fine. And furthermore, you can do 2 or more applications a year, fine, no big deal. And again, they've said, and an employer can only resist those flexible working applications on one of, so far, 8 grounds. Sounds good until when you read into the 8 grounds and you think 2 things. One, this is a bill that is still going to go through a whole lot of consideration, and the RPC, the Regulatory Policy Committees, have already shot down the government's 8 grounds as being inappropriate. And B, if you were a cynical reader of the 8 grounds, and I'm not going to say like I am, but in a sense like I am, and you can find any way to justify a business decision within those 8 grounds, business objectivity, because the legal test is what is reasonably, objectively justifiable. It's not what is right. It's not even what is good. It's what is justifiable from a business perspective in the context of that business, in the context of that point in time when the decision was made. So again, a lot of noise in the bill, but it's not really achieving significant change to help A, the employee who needs it most, or B, the employer, particularly the small employer that needs to flex to stay in business.
And Gareth, maybe staying on that point if we can. So if we think about the proposed rules or legislation on unfair dismissals, I think as it currently stands, unfair dismissals in the UK for employees are there's protection after 24 months, if I understand that correctly. Gareth, is that correct? And in the Employment Rights Bill, they're seeking to bring that down to, is it 9 months? Is that correct, Gareth?
Day one rights.
Day one?
Rights
Wow.
for dismissal.
Wow.
Well, yeah, in principle,
Yes.
but again, that's the issue there, Conor, is
Yes.
whenever it was suggested that day one rights for unfair dismissal, business and industry immediately reacted negatively and said this is simply not going to work. It's going to be impossible for us, because how do you deal with recruitment of an individual who simply and really clearly does not work? The Employment Rights Act 1996 still doesn't really deal particularly well with that kind of situation, because is the individual in the probationary period? Are they in your disciplinary process? Which rights apply for that process? So with the Employment Rights Bill and someone getting day one unfair dismissal rights, it immediately means a complete rewrite of your probationary period rules, a complete rewrite of your disciplinary procedure rules on grounds of capability, and it involves a completely different ground level utilization of management in terms of supervision, training, induction, assessment, etc., etc., etc. So it just doesn't work. Nice soundbite. And the Labour government's response to that was to say, what we meant was day one rights for unfair dismissal at the point where you become an employee, i.e. at the point when you satisfactorily complete your probationary period. And in the same breath, they said in the probationary periods, which are classically in GB 3 months and in Northern Ireland 6 months, although that's not the absolute rule, that's just what business seems to default to. But the Labour government have said, what we'll do, we will extend the probationary period up to 9 months. And only after you complete your probation after 9 months will you unlock these day one rights. So it's not a day one right at all.
Okay.
Not unless they refine that and change that as it passes through the Commons. And it's debated upon. But at the minute, that's a really clear example of how the Employment Rights Bill in its current form does not work.
Yeah, I agree with you, Gareth. And I was just thinking about the small or medium-sized employer, particularly in that case, if those rights were to be considered day one. I mean, imagine how problematic it would be for a small company to hire someone and then go, okay, she, he, or they are not working out, therefore we need them to go, and then they have to defend some sort of suit or claim, which would be probably quite problematic, I would say.
It creates there's an awful lot of the legislation that has created inadvertent problems for the small to medium-sized employer. Even the national minimum wage, if you recall, whenever that came in, that effectively killed apprenticeships overnight, because businesses just could not afford to pay a guaranteed hourly rate to individuals who subsequently lost out the opportunity to get the first rung on a ladder in relation to the pathway to work if they did not go through undergrad, university, etc. So that was an inadvertent misstep, well-intentioned, but it created significant difficulties for a lot of people in their ability to access their first job. And we're still living with the legacy of that, which is why we're seeing so many government schemes talking about apprenticeship models, etc., to try and help people back into the world of work who are unable to access a career through apprenticeship models or the traditional apprenticeship model. And that largely came out of the national minimum wage legislation, which is not going away. So I think that's another issue with these day one rights. You're quite right. A small employer is not going to take a chance in recruiting someone if they feel that they're potentially going to be facing an unfair dismissal piece of legislation or case rather within 2 or 3 weeks, in which case they probably will look into agency worker opportunities. And ironically, they will look back into what traditionally were some of the poorer working practices, which is, well, can we get a 0-hour contract worker here, unregulated? What can we do with that? So again, it's little bit like the government playing whack-a-mole here.
Yes, Gareth.
They're dealing with one issue, but they're creating others. And it just seems to be a lack of joined-up thinking, which is a real shame. Whenever this piece of legislation is so seismic, to my mind, like the Employment Rights Act and Order of 96, this has got to last for 30 years. And at the minute, it needs a lot of work.
Yeah. Okay. So, what's the space? I'm just thinking, though, Gareth, around some of the work impact for a large business, a large enterprise, a medium-sized enterprise, and small enterprise to put this into practice once it goes through the House of Commons and receives its assent into law. I mean, so some of the changes that you've referenced there are quite considerable in terms of the handbooks, the HR policies, contracts, what all that looks like. And that's seismic in addition to the minimum wage and the other things that you've mentioned. I think it's going to could be good for lawyers though, Gareth. I'm thinking about that. Could be good for HR practitioners too, of course.
Look, yes, you're absolutely right. But equally, I see a change in the legal system, the profession as well. To my mind, we exist to help serve business. We in employment law are there to help deal with issues and to help guide whenever things go wrong. On an individual basis or on a larger scale, when you're looking at major change and restructuring, etc. We shouldn't be the kind of lawyer that parasites on bad law to hammer the small employer because they have failed to keep up to speed or comply with a new piece of legislation. That, to my mind, is not truly helpful for business or the wider economy or society. And I think it creates this sort of blame culture, and lawyers have bad enough rep, rightly so, for being hospital ambulance chasers, etc. And I think that there's a real potential for that to come into employment law land as well. And I think that's a danger. And I think on a wider scale, in terms of the challenges for employers and the way the industry is changing, I think over the period of my working as an employment lawyer, 25 years, I've seen a real shift in the responsibility from the state in its broadest sense to the private sector employer.
Yes.
And I'll come back to that because the Employment Rights Bill touches on that as well. And I know that's a big feature for your listeners.
Yes.
But if you consider even simple things like the pension, when Conor, and I know you and I are of the same sort of age and stage, but
we are.
When
we're very young.
There was a thing called the CERCS, the state pension.
Yes.
And then because of underfunding and because of the different or the size of the demographic change and people living longer, it was very quickly realized that the state pension would not survive. It couldn't. So then there was the state's second pension. You had to opt in and out. That didn't work. So then we had the nest pension, then we had the stakeholder pension. We have successive governments trying to work out how on earth they're going to deal with this deficit. And in the end, we now have auto enrollment. In other words, the employee and the employer are obliged to help begin to fund for retirement. So in the space of not even a generation, there's a fundamental shift in responsibility in relation to pensions. But you see it in everything else. Healthcare is the next piece. Whenever the NHS is struggling, so employers are increasingly being encouraged to set up PHI schemes and to fund health insurance for their employees, because again, the state can't support and fund fully. National minimum wage, 0-hour contract working, all of that. The emphasis has been placed on the employer to manage this, and we see this now in the Employment Rights Bill, whereby employers are also now obliged to do everything they can to the phraseology is take all reasonable steps to, that's putting an onus on the employer that's almost impossible to police. And yet that is one of those, again, bad pieces of law that is going under the radar within the Employment Rights Bill because other aspects of the bill are taking increased focus. But I do think that whilst we said this at outset, employment law is dynamic. It is changing rapidly in any way. It always has. But employers now, I think, are in an almost impossible position of understanding and navigating the currency of the employment law protocols in the United Kingdom, whether that's GB or NI, and it's only going to get worse. And it's only going to get worse because of overly politicized legislation, which hasn't been well thought through, and also legislation which just is not keeping pace with what's happening in the real world because, COVID, work from home, the return to the workplace, tech, and the increased globalization of the workplace has fundamentally transformed work and how the new generation of employees coming into work and view a career in the space of 2 or 3, 4 years, which has not happened prior to COVID, etc., for like 30 years of the norm, which was a slight light touch on the rudder, but basically a very, very low variation on the theme. Whereas now the employees and the candidates coming into the workplace, the applicants, are of a fundamentally different mindset. And this legislation, albeit is supposed to future-proof, it's already obsolete in so many regards. And I think the central government needs to be better. And what you will also find in the vacuum created by bad legislation is the court of public opinion, social media, influencers are encouraging employers to move much faster than any legislative process actually does. And that's what I find absolutely fascinating. I could talk for an hour on that just itself, but forgive me, get off my hobby horse just for a second.
Well, Gareth, this is what I love about our conversations, and this is why I really wanted to have you back on the show. And Gareth, when I think of unintended consequences in legislation, I always think of IR35 in the UK, particularly in the private sector. And I don't know if you've been following what's happening in the Netherlands at the moment, but they're introducing an IR35 type test for independent contractors or freelancers. And one of the initial impacts of this is that they've had their worst ever year since records began for freelancing and independent contractor workers coming into the marketplace. They're essentially running scared is what the data is saying. And I think you and I have talked about this many times before, Gareth, whereby with IR35 in the private sector, in certain cases, you've essentially got taxation without representation. And what I mean by that is that you're treated as an employee for tax purposes, but without any of the corresponding rights if you're deemed inside IR35. Now, what I want to talk about, Gareth, or what I'd love to hear from you rather, is since IR35 was introduced and we last spoke, what has changed, and have you seen an increase in the level of investigation or indeed enforcement activity in relation to IR35, particularly in the private sector?
Sorry. IR35 in the UK, I think, is a total mess. I'm encouraged to hear that Holland is coming up with something, and one would hope that the UK government, let's assume the Holland model is efficient. The UK government really has to look across at that and learn from it. There's a fascinating case has just been reported, Mantides versus HMRC, and I think it illustrates the predicament of IR35 in the UK beautifully, because this is an individual, a doctor, who, like almost every doctor going through undergrad in the UK, is told to set up a personal services company. And because doctors and dentists in the NHS are entitled and encouraged to do a degree of private work, and they are told at outset that the only vehicle for that, or the most appropriate vehicle, is setting up a limited company, personal services company, etc., etc. HMRC have sought to try and close the loophole on that within the income tax, earnings and pensions legislation. and with an expansion of the IR35 rules. Those rules have been subject to debate, ebb and flow for a number of years now. And we believed we were getting so far with them, and there was a better understanding of IR35 as to how it would change in the UK, because the government, and it was actually the Tory and the Liberal Democrat government, really got onto the skin of IR35 in a big way whenever they were trying to resolve it. They recognised that the HMRC CEST tool, the CEST, the Check Employment Status tool, was flawed. HMRC still recognise it as a flawed tool. It's a guide, not anything else. And fundamentally, the problem was, in a nutshell, that the tax assessment of employment status was different from the legal assessment of employment status, because we didn't have an appropriate definition of what was an employee or worker, even with the Employment Rights Act 1996. So we have this huge problem. We have the tax accountants taking one perspective, we have the lawyers taking another, and we have the poor employer stuck in the middle, not really knowing what's going on. The CEST tool is flawed, and even though they keep tweaking it, everybody understands it's flawed. And then we thought that the UK government was going to resolve it. They got so far. They have changed the rules and the expectations. But again, it's neither HMRC taking responsibility for this, nor the CEST tool. It is the individual themselves, combined with the employer, to make their own assessment. That assessment, whenever the employer goes through its entire suite of suppliers and payroll operatives, decides whether or not someone may or may not be IR35 responsible. They run that election, which is not straightforward. That election is communicated to the individual, in this case the doctor. The doctor goes to his independent financial advisor and says, this is not right. I am not an employee for IR35 purposes. I must be, I attract a different tax band and a more attractive tax band. Please investigate. Mantides then run a 10-year piece of litigation. The court of first instance found for him. The court of second instance found for one of the employers. There was then a hiatus while it went to the UK Supreme Court. The UK Supreme Court, after 10 years, has concluded right back with the court of first instance. So this individual has now been assessed as liable for tax as an employee under the IR35 rules from 2015. So everything that has happened subsequently has done absolutely nothing to clarify nor codify what the situation is. So what total mess, I think. And this poor individual must have a huge legal bill, because not only did he have to take it through 3 courts of law instance, he ended up with the Supreme Court. There's no further right of appeal from that. So that is how the law currently sits. And in answering the question, interestingly, the Supreme Court ignored the CEST tool, which is the HMRC guide, and went right back to core legal principles of control, of contract, and of the consideration of mutuality of obligation was the phrase I was looking for. That mutuality of obligation phrase, which is a legal phrase that means nothing to the common man and is open to case law, ebb and flow. That's what we're back to. So that's where we are, IR35 at the minute, Conor, and I don't think it really speaks too positively for the UK system in terms of what is the alternative model and how do you incentivize genuine entrepreneurial working, and yet making sure that the entrepreneurs serve a supplier well, pay the correct amount of tax, because the risk under an IR35 breach rests with the user of the services now as well. So you're not even sure what you're contracting with and whether or not that creates a problem with HMRC further down the line. So a pretty unhappy place when it comes to IR35.
My word, Gareth, that's revelatory. It's also insane to my mind, but it probably speaks volumes about some of the fundamental problems with this legislation, how it's been enforced, how it's been designed. But I think that case you've referenced is really instructive, and I think a lot of our audience will find that absolutely fascinating.
Yeah, absolutely.
And probably find it insane.
I think, I think what, if you look at some of the issues that are facing employers now in industry, some of the real things, yes, we have this sort of transition of responsibility from the state to employers, I think, for a whole lot of issues. That's definitely a significant thing, and that's been going on, as far as I'm concerned, for the last 15 years. It's a slow burn, but it's happening. But the thing that I find really fascinating is the impact of COVID, actually, and the change that is required or created within the workforce, because we have employees, some of whom have never worked in an organization where the cultural ethos was 9 to 5, Monday to Friday, working full time in office, for example. Instead, we have a lot more freedom. We have organizations that recruited with the tagline, work where you want, when you want, how you want. In the Republic of Ireland now, it's not in the UK, but in the Republic of Ireland, there's this right to be forgotten. So the employer cannot contact you outside certain core hours. So in a very short space of time, the mindset of the employees has fundamentally changed, as opposed to getting a job and clinging on to it and doing your best for that. A lot of employment candidates coming in now are thinking, yeah, I like what you do. I've read your ESG policy. You will pay me a really good wage. I see you as a stepping stone. You are the first job that I will do before I move on somewhere else. And when you're reading up job applications and you're seeing candidates saying, I want to join such and such an entity because you will be a great place to start my legal career or my engineering career, etc. Most employers are pretty unhappy about that, because you don't really want to be recruiting and training someone to lose them to a competitor. But that's precisely what's happening. And if that was just on a localized level, that may be manageable. But when you consider what tech has done, which is wonderful for the individual, we have globalized working from, little old Northern Ireland. And we talked about my origin story, your origin story. I don't have to work in Belfast. You can work anywhere for international global organizations doing wonderful work. And that is just a feature of the new world of working that employers need to acknowledge and embrace if they can. Because it's not going to go back in a box. It's not going to change. You might get the employee back in the workforce in certain industries and back into the workplace for 4 or 5 days a week, maybe, not without issues in morale, etc. But fundamentally, we're working with a tech-savvy, globalized workforce, which is great for the individual, tough for the conservative business owner,
And Gareth, on that point, that we have seen these return to office mandates as they've been described in the media. A lot of it has been US centric, and to be fair, companies like JP Morgan and other large institutions. But in the United Kingdom and Northern Ireland, Gareth, are return to office mandates legally problematic under employment legislation?
Yeah. So I don't think they do. Um, I don't think they breach any employment legislation whenever there's a return to office mandate. What they might do, and where the case law develops, is where they breach individual contracts issued by an entity like Morgan Stanley to the individuals, either in written format, where they've recruited with an express term saying this will be flexible working, work from home, etc., 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 or where at interview, and this frequently happens, employers are so keen to sell their business to the candidate, they will say, oh yeah, the contract might say X, your place of work will be Central London. But the reality is, we're a flexible employer, you can work where, when, and how. The problem with that is that business is obviously changing and will require from time to time, certainly, the employee returning to the office more often than not. And that's where employees do have arguments and cases saying, well, actually, this is misrepresentation because you recruited me fundamentally on the basis that my contract required X, Y, and Z, and now you're trying to impose something completely different. So that is a unilateral and material breach of contract, hence litigation. Okay. But there's no underlying legislation really that commits to an entitlement to work from home. Your new flexible working guidance within the Employment Rights Bill does entitle employees to ask for, but unless it's given and then worked, it's okay for the employer to bring an end to this temporary transitional piece. Your real problem for the employer in that circumstance, even if they hadn't made verbal assurances, is the morale hit, and the fear that if they seek to bring someone back who is a really good employee on so many levels, but that employee does not want to come back into a semi-rigid workplace, they would actually rather work when, where, and how, and they're good at that. The problem is that employee becomes a flight risk. And that's where employers are now, in the absence of legislation and the absence of really strong and clear supportive guidance, they are making some bad decisions and creating more issues for themselves than not. But for the time being, unless and until the Employment Rights Bill tidies some of these things up in relation to flexible working, etc., there's no legislative concern for me, I think, that employers need to be aware of in relation to enforcing a return to work mandate, subject to health and safety and, the old school pieces of legislation like health and safety, workplace numbers, temperature in the workplace, hours, etc., space, time away from a visual display unit, good stuff. None of those should cause any concern. The issue is more pragmatic in relation to morale, and B, legalistic, where the employer has gone over and above the statutory piece and given a contractual obligation or an entitlement to something that now they want to roll back on. That's where your big problems land.
Yeah, I agree with you, but I think that's great to hear, Gareth, on those 2 points. And I think any employers that are operating in the UK thinking about an RTO, return to office mandate, I think they're 2 things that they should definitely consider amongst other things. So, Gareth, a question I've been down to ask you about since we were trying to get this podcast scheduled is around artificial intelligence and artificial general intelligence and its potential negative impact on the labour market, specifically in terms of job creation and jobs displacement. But also, are you concerned on AI's impact on lawyers in particular?
So I didn't quite get that. You've broken up again.
Sorry, Gareth.
We're just on the way to AI.
Yeah, exactly, Gareth. Go for it. Go for it.
Yeah. So I think the impact of AI is yet to be fully felt. But I do think it's going to be another seismic change. If you think back a few years to working in an office whenever the internet came along, the people that could first adopt the internet, even if it cost a lot of money and had a little bit of a change to do that, were considered thought leaders and a little bit crazy in some regards. But within a very short space of time, the internet has become second nature to everybody in Western and Eastern, in fact, globally. All society couldn't really cope without the internet. It's just a feature of our lives. I think AI is going to get there. It's going to get there very, very quickly. But the difference is, whereas the internet was access to information and a lot of stuff that you frankly don't need to see or want to see, but you could get it instantaneously. AI is slightly different. AI is helping us problem solve, and it is making certain people a little bit lazy in certain aspects. And it's also dependent basically on the algorithms that go behind it. And it's only as good as the suite of algorithms fed into it. We see a number of issues with that. Some of it is there's unconscious bias comes into the nature of the algorithms that are created to help facilitate an answer. So your answer within AI is closed because it's only as good as the information that's fed into that and the way it's been programmed to sift and analyze. So it still requires a good, healthy dose of human oversight So I'm keeping myself in a job here, Conor. There's no doubt about that. But the other side, joking aside, where I see AI having a huge difference, particularly in the service industry, is that so many aspects of professional service life can be packaged and can be dealt with so much more efficiently, so much more accurately by reference to AI. I see that in accountancy. A lot of my accountancy clients, audit ticking and bashing and then running the mathematics, that can all be done by AI. It just needs an audit supervisor, if you like, to make sure that some of its checks and balances are correct, but it will reduce the number of lower level staff needed for that old school job role. Due diligence, particularly in the legal sector and in understanding how business operates, etc. You can throw in all the accounts, you can throw in the management accounts, you can ask for assessments, you can ask specific questions. That information, which previously would have been poured over by individual humans and would have taken days, certainly hours and hours and hours, if not days and or weeks, depending on the scale and the number of documents even to be found, can be done in a matter of minutes by AI. So what does that mean? I think it's going to mean a large number of job roles are going to change significantly. It doesn't necessarily mean job losses yet. But here's an example. In my world, which is a law firm, we would take on, for example, 10 trainees every year. So we're taking on 10 trainees this year, even though we have spent a lot of money on an AI system, which is a closed system, legal AI system. And it's very, very good and scarily good. But we've still taken on the 10 trainees, but their training program is very different from the training program from 2 years ago and remarkably different, unrecognizable from 5-10 years ago. Point being, one of the expectation is that they will embrace AI. They will learn how to use AI in a way like dinosaurs, like I don't or won't. And what that will do for their training regime is that instead of handing them a question and saying, those are the 10 books that you need to go, and you need to hunt through those and find those, and you need to write a summary and give it to me, and we'll do brief together and go and meet the client. Instead, we're meeting the client in about 20 minutes. There's the question. There's your AI opportunity. You now need to go and ask the correct questions, put in the right information you need, and you need to get that response back. So that will happen. They will produce the same level of information. They'll just do it much, much faster. The senior solicitor will still have the human element to make sure that it actually makes sense. And we'll be off and running. So I think in a large commercial law firm like ours, we will harness AI more quickly than a lot of other entities will. We will ask our people to adopt it and adapt their working methodologies to ensure that they work faster, more efficiently, and ultimately justify their existence. If they can't do that, then we will see a reduction in the number of trainees that we bring in. Or if our model is ill-considered and doesn't work, we will see a reduction in the number of staff doing that. I think smaller organizations will struggle. They'll find it much harder to do that. They'll find it much harder to pay for a good AI system, and it will create inadvertent difficulties for them. But I think AI is going to have a huge impact on the workforce, and not just in the kinds of jobs that are out there, which will change, but even if the job title stays the same, how you do that job is going to fundamentally change. And that's where I'm going to see it. That's where I'm going to see it most in my particular industry and in my firm where it sits commercially within that industry. We are harnessing it as best we can, but the individuals within our teams who will still be employed to work on it as trainees, their job role is fundamentally different. And instead of, for example, 4 classic 6-month rotations between property law, banking law, litigation, whatever, one of those rotations will just be legal tech, AI. And those individuals will be expected to become the next generation of experts who will do 2 things with that. One, they will support traditional lawyers, traditional law. The second one will be to exploit that and see what kind of new types of law are there out there that need support, comtech, different kind of litigation, etc., etc. It will be remarkably different. And whilst the internet took a while to pick up and move from a server in an office to a handheld device, which 12-year-olds can walk around with, which is more powerful than that which we had, 10 years ago. AI is going to be a much more rapid uptake, I think. So I think we need to be much more fleet of foot even than we were with the internet.
Yeah, I agree with you, Gareth. And I think back to 21 years when I started my apprenticeship in a criminal law firm in Belfast, or 22 years ago, it might have been, Gareth. Completely different to what you've outlined there. Would you mind taking the prediction of work question?
Yeah. So the future of work, that is like the $1 million question, isn't it? And it's a really difficult one to answer, but I do think it's fascinating. AI is going to have a huge change in the world of work, as we know. But I think and I've also talked, I think, about the transition of responsibility from state in its broadest sense to the employer. I think we're going to continue to see that trend. Successive governments, doesn't matter whether Labour government or otherwise, that's going to continue. I think in the short term, we are in a difficult place. I don't want to be overly political about things, but to my mind, employment law legislation is so critically important to everybody that it should be apolitical. But that's just not what we have. And if you look at, US politics, or you look at UK politics, we're seeing big swings in the dynamics. Trump won effectively both houses. The Keir Starmer's Labour government won such a landslide victory that there's no effective opposition in the UK at present. So one of the things that I find unhelpful in the Employment Rights Bill is that one aspect of it is entirely focused on unpicking what the previous Conservative government did in relation to trade union law and reform. So if we have successive governments in a very politicized environment using legislation to mirror their party politics as opposed to what is best for society, community, the business, in the context of our time, I think that creates the opportunity for really bad law, potentially, and especially unstable legislation, because we will have successive swings of governments, and what they will do is, if they're doing unpicking what the previous government did as part of their election manifesto, then that's not good for business. It's not good for investment. It's not good for the employer. It's not good for the employees. So I would love to see a lot more stability comes into both US and GB politics in relation to where we're at, where we sit. And I think that's going to be really important to try and settle down legislative change and get us back to just doing business, not worrying about government point scoring. I think that's really important. I think the DNA of the employee is evolving rapidly, whereas in the 2000s, broadly speaking, the employee was largely focused on what the employer needs were, what case law legislation said, and then a very small spectrum was technology, if you like, the advent of the internet and what that might do and how that change worked. Whereas the DNA of an employee applicant now is fundamentally different. What the employer wants is concertina down. What legislation does is still there, but it's operating in a vacuum because it operates so slowly. Then we have the influencers. We have recruitment consultants and what they say and do and how they influence people and unsettle people. We have social media influencers generally, and the internet. And what social media has done is create this instant appetite for gratification, and you constantly see imagery of people living their best life or working their best career somewhere else. No one really cares or understands just how much work and trickery goes into that. But nevertheless, people are being sold a dream of instantaneous grass is greener, I must have, which most employers cannot deliver immediately. So I think that's going to be increasingly important, particularly with a globalized workforce and tech, which allows us to work globally. So the future of work is going to be very different, very fluid, I think. And as the pendulum swings in relation to that in favor of employee and job applicant desires, you're going to see employers stretched to breaking point. Some will be sufficiently big and wealthy enough to accommodate, and they will probably do really well for a period of time, but the vast majority of employers will reach a breaking point faster, and then that pendulum's going to have to swing back a bit. How far that swings back and how quickly, no one can guess. But I do think that a lovely little example of how quickly that pendulum can swing, we discussed in relation to the return to office post-COVID and work from home work, how, when and where you want. It's not efficient, or rather, it's not efficient enough for enough businesses which are still, broadly speaking, conservative and transition to a more modern model much more slowly. Employees' desires are more needy, and they expect change faster than most employers can deliver. So there is a disjoint coming, I think, and I think there will be a resetting of employer expectation, which employees must meet. Otherwise, in the short term, there'll be a fair amount of unhappiness, a lot more wasted time with HR trying to sort out grievances because the job proposal, which invited the individual in, does not meet with the employee's expectations when they start work, and that's going to create difficulties all around. So doom and gloom, Conor. I don't want to be too negative about it. There's a lot of opportunity out there, but I do see that pendulum beginning to swing back, and it's going to create some tension in the workplace in the short term. But equally, old school employers, if they do not embrace AI, if they do not embrace increased flexibility within acceptable parameters within the workplace, they will be the big losers, because tech allows employees to move much more regularly, much more easily throughout their career. And I read a really interesting and worrying article which said that the generation, whatever it is now, the new starter employee will expect to work in about 11 different jumps within their career. They also don't expect to retire anywhere close to 65. They would like to go much sooner than that. And their pay expectations are out of this world. So that, I think, is fascinating because that is also unreal. Whereas in our situation coming through, we probably would have thought maybe 2 to 3 jumps, always upwards, after you've spent a good bit of time, built your reputation, and one job is conditional on the previous being a success. So you give everything to it. That mindset is just not there anymore. I'm not saying the new breed don't want to achieve and do well, but if I recruited anybody and said, delighted to have you, we're going to give you a career here for 40 years, we're going to give you everything you want, you will see out your time in this building or maybe working from home for part of it, and you will have a wonderful career, they would walk out the door, not interested. And so the DNA of the employee, I think, is changing as well, and that's the single biggest change. Legislation will always be, broadly speaking, obsolete by the time it is issued, but social media, the pace of change, will be driven by the court of public opinion and will be driven by employee expectations far more than it is driven by the employer or any government.
Wow. Gareth, thank you so much for that. I think that's been a tour de force in terms of the changes that the Employment Rights Bill in the UK are going to bring about, some of the potentially inadvertent and unintended consequences. But Gareth, I think that's a lovely way to finish our show today. And I just wanted to thank you, Gareth, for coming back and for sharing your knowledge and your opinion, your expertise, of course, in a non-binding advisory way, and your experience, Gareth. It's always great to listen to you and have you on the show. And Gareth, for the benefit of our audience, where's the best place that they can come and find out more about A&L Goodbody and yourself?
Thank you, Conor. And look, I just say it's always a pleasure to talk to you. You give me free rein, and it's such a freedom and a joy to do that, especially with the caveat that it's not legal advice, it's just perspective and opinion. But for those of you who do need legal advice, the way to do it is the easiest way, I suppose, is going straight through the website. A&L Goodbody, ALGODBODY.com. The website is effectively our Dublin office. That's the mothership, but you can find all of us in our London offices, our Belfast offices, and our small US satellite offices through that mothership. And look, we have such a good bunch of good people. You know, as I said at outset, I wouldn't be working here if I didn't think that they were, you know, they had the right level of integrity, professionalism, ability, and fun. So yeah, look, get in touch at any time and I'll help direct you to whoever you need to speak to in any jurisdiction. Not a problem. But thanks, Conor. Always a pleasure to speak to you on this.
Thank you, Gareth. And I think the story of A&L Goodbody in Northern Ireland and across Ireland and the UK and around the world has been a phenomenal success. So, Gareth, continued success to you and your team and to A&L Goodbodies. And really good to have you on the show. And we'll be in touch. Thanks, Gareth. Take care.
Thank you for listening to the Open Talent Report with Conor Heaney. If you found this podcast informative and engaging, make sure you subscribe, tell your friends, and follow us on all your favorite streaming platforms.